All right, a very beautiful afternoon at 5 p.m. For a conversation forward. Yes, remember it's a conversation development. You're listening to Nigeria Info, your talk news sport radio, Kadagori Battle, and this is. I've got two lawyers via the phone joining us on the show right now. But before we get to the lawyers, let's take a look at the topic for hour. Now, I want to talk about something that emerged as a result of the announcement by the courts yesterday. The State High Court Justice made certain statements, made certain pronouncements that have put the state in some kind of situation, and certain reactions have popped up. Certain people have spoken about it. For instance, yesterday, Professor Wokocha spoke about it. We had some other lawyers, speak on the issue, but the one that caught my attention was the statement made by the Commissioner for Justice, Rivers State, and he did say that the court did not necessarily rule on the matter. Did not rule on the matter, as a matter of fact. And that there is a subsisting court judgment from Justice Charles Wali. And what I picked from his statement was he was making reference to the judgment, and he mentioned section 272 subsection 3. And I had to go study. I'm not a law student. I'm not a lawyer. But I had to go study section 272 and subsection 3, and it talks about the Federal High Court having jurisdiction over, whether a governor still remains a governor, or whether a Speaker of House of Assembly still remains a Speaker, and all of that. And that's why I have now invited two lawyers. I think you know both of them. I've invited Henry Ekine, who is the National Legal Advisor at the Committee for Defense of Human Rights, and I've also invited God's Power Egbule, a lawyer. Has been on the show a couple of times, and we will be listening to their interpretation of that section of the Constitution. And this is why it is necessary for us to interpret that section of the Constitution. Now, if indeed only the Federal High Court can look at such a matter, it means that some of the pronouncements that we've been getting from state high courts may not necessarily have legal backing. And this is me talking as a layman. Of course, we would have the lawyers give their expert view on the issue. Welcome, Henry Ekine, Esquire. It's good to have you on the show.
Yeah, thank you for having me.
And welcome, God's Power Egbule. God's Power, can you hear me?
Yeah, I can hear you.
All right, thank you very much for joining me on the show as well.
My pleasure being here.
All right, so let's start with you, Barrister Henry. Section 272 subsection 3. How do you interpret it? How do you understand it? Can you educate us, please?
Thank you. Section 272 of the Constitution of the Federal Republic of Nigeria excuse me, is the principal section with respect to the jurisdiction of the High Court of a state. And that means it is the law that provides for the power of a state high court to entertain and determine any matter presented before that court. And after consideration of that matter, come up with a decision, that is a judgment, one way or the other. The same way you have the Constitution providing for jurisdiction for other courts, but particularly Section 272 is with respect to the High Court of a state, including the High Court of Rivers State that is established by the Constitution.
All right.
That's general. Now, specifically, Section 272, subsection 3 makes reference, still under the jurisdiction of the State High Court, makes reference to the Federal High Court with respect to the specific issue of declaration of the seat of a member of a House of Assembly as either vacant or otherwise. Now, my take is this. It is very fundamental in every... Hello?
I can hear you. Go ahead. I'm listening to you.
Yes, it is very fundamental for every court to be properly constituted to be able to validly, entertain, consider, and determine any matter that has come before it. And that is jurisdiction. To be that properly constituted, it may be in terms of number, in terms of location, in terms of having the competence to entertain that subject matter in that suit, really. Now, this has always been, it's not the first time that we have had the high courts created. But when we had the constitution altered in 2010, that's the first alteration, first amendment, the subsection 3 of that section was established or included to make a new subsection of section 272. Now, for me, in my view, that subsection 3 of section 272 makes further the concurrent relationship between the Federal High Court and the State High Court, to the effect that the subject matter there, which is the power, the authority to be able to determine the question as to whether the term of office of a member of a House of Assembly of a state or a governor or a deputy governor has ceased to exist, or rather has become vacant. I consider that subject as now being a subject that the State House of Assembly can can determine, and then the Federal High Court can also share in that authority, that jurisdiction, to determine, to entertain and determine. That, for me, is my view. And
right.
legally, I will make reference to section 251 of the Constitution, because without reading section 251 and section 272, one would not be able to establish this argument that section 272 sub 3 is not an exclusive jurisdiction per se for the Federal High Court. That can only become clear when you read also together with the provision of section 251 subsection 1, particularly with respect to which matters come under the exclusive jurisdiction of the Federal High Court.
Okay. All right. So I'm going to God's power now. God's power, over to you. Now, how do you interpret subsection, or rather section 272 subsection 3, where, some people are, I think I've also listened to you argue in that direction, in that stead, that it does mean that only the Federal High Court can deliberate on matters concerning to the validity of a governor or a speaker or legislator of the House of Assembly.
Okay, Mr. Kalera, quickly, I don't know if you can hear me, so that I'll just state my point. Can you hear me clear?
I can hear you loud and clear. Loud and clear. Go ahead.
Okay. You see, whenever we're interpreting the provisions of a constitution, we must do so without any sentiment and emotions. And where the letters of a constitution, the spirit of a constitution are clear, that we shouldn't read meaning into them. This is because the express mention of one thing means the exclusion of the other. If the constitution has provided, by virtue of section 272 sub 3, that the determination of as to any question whether a member of the House of Assembly has lost his seat or that seat has become vacant, jurisdiction of such matter rests squarely with the Federal High Court. That is the provision of section 272 sub 3. The argument that jurisdiction is shared between the State High Court and the Federal High Court defeats the purpose, the intent, and the spirit of section 272 sub 3. And that's like bringing an external argument into the provisions of the Constitution. If the Constitution wanted the State High Court and the Federal High Court to share such jurisdiction, it would have made it very explicit. It would have made it very explicit. But you and I can see what section 272 sub 3 says. He said the Federal High Court shall have jurisdiction to hear and determine a question as to whether the term of office of a member of the House of Assembly of the state, a governor or deputy governor, has ceased or become vacant. You can't see these express provisions of the Constitution, and you want to read me to say that that jurisdiction will now be shared between the state high courts and the Federal High Court.
Now,
with the greatest deference to my learned friend, that's a misconception of the law.
Okay, now God's power.
That definition of the law is without any legal foundation.
God's power. Now, I've got a question for you. Barrister Henry Ekine laid a foundation and said before it was amended, subsection 3 was not always a part of the Constitution. It was added eventually during an amendment process. That means before the amendment, it was believed that the state high court could handle such matters, right? Now that this has been added, there is nowhere in the Constitution that says that the power was removed from the state high court. I don't know if you can explain better.
That argument suffers from poverty of logic, and reasoning.
Okay,
show me in the provision of section 251 of the Constitution which provides jurisdiction for the state high court, where the Constitution provided that any issue with respect to the determination of whether a member of the House of Assembly seat has become vacant or seized. Show me where it is in section 251. If it was provided for in section 251 and provided for in section 272, then you can make this argument, and maybe we'll begin to say it's plausible. But since no provision of such was made in section 251, this provides for jurisdiction of the state high court, and it says in section 272 sub 3 that such determination of such question will not lie with the Federal High Court. I am telling you that you can't read into the Constitution what is not there. This is like interpreting the Constitution with so much emotion and sentiment. Show me in section 251 where the Constitution says that that question will now be determined by the state high court. So show me, read section 251 and tell me. Because this section 272 is explicit that the Federal High Court has jurisdiction.
Okay, I would have to pause you. I've got a commercial, so gentlemen, please do stay on the line.
The Association of Christian Schools International River State Chapter
have Henry Ekine and Godspell Egbule, both lawyers, in the studio, and we're looking at the 27 lawmakers, the state high courts jurisdiction, the various courts in the states, their jurisdiction, the state high courts to be precise. And we're looking at section 272, subsection 3. Now, just before the break, both lawyers had spoken, and they, I think, made reference to 251 of the Nigerian Constitution, and I wonder what it says. I'm looking at my constitution now, my copy of the Constitution rather, and it is talking about the jurisdiction and the functions of the Federal High Court. Now, barristers, how does this in any way relate to 272 subsection 3 of the Constitution? I'm going to start with you, Henry Ekine. Let's get your thoughts, please. Welcome back.
Yeah, right.
Can you hear me, Henry?
Yes,
Mr.
Kalada,
I didn't hear you.
God's power. I'll come to you. Just stay on the line. I think the network is shaky. But let's.
Yeah, same here, Kalada. I'm actually struggling to hear you. It appears the connectivity isn't quite the best here.
Okay.
But I listened to my colleague, and I'm understanding the subject of this discussion this evening. I would imagine that I'm still on track. But I said that you cannot read section 272, subsection 3 in isolation without reading section 251, particularly subsection 1, when you are making an argument with respect to the exclusive jurisdiction of the Federal High Court. We're not talking about general jurisdiction or concurrent jurisdiction of the two courts. The Federal High Court and the State High Courts remain courts of concurrent jurisdiction. It is only the Federal High Court that has constitutional provision with respect to certain subject matters that have been excluded to just that court. Otherwise, the jurisdiction of the State High Court appears to even be limitless. But arguably, it is only the Federal High Court, and that is not fortuitous, it's not by chance. The origin of the Federal High Court was such that it was previously a court that was specialized in areas of taxation and revenue. It was the revenue court. So certain jurisdictions with respect to certain subject matters were reserved exclusively for that court. And that is why when the court was established under section 249 of the Constitution, it's a different court from the state high courts. Now, after establishing the court, the Federal High Court under section 249, section 251 is specific with respect to the jurisdiction of the Federal High Court. And it's clear, unambiguous in interpreting statutes, particularly the Constitution, when the words of the draftsman and the expression are so clear and unambiguous, you don't struggle to add anything or even employ any of the tools of interpretation. Clearly, section 251, subsection 1, is the only provision you would find exclusive jurisdiction with respect to the Federal High Court. And it listed from paragraph A until about paragraph R and S,
yeah,
as to subject matters that are exclusive to the Federal High Court. And you cannot add, no individual, no judge can add an item in the subject matters for exclusive jurisdiction of the Federal High Court, except the Constitution itself.
Okay.
Now, if the drafters of the Constitution, when we agreed to alter the Constitution in 2010, the first alteration, if we intended to add to the list of subject matters that were exclusive to the Federal High Court, the opportunity was amply there for the National Assembly to add to that list of matters that were exclusive to the Federal High Court with respect to determining matters that connect or relate to determining the office of the governor or deputy governor or a member of a state house of assembly. That's clear to my own argument. Now, when even we did that alteration in 2010, the Constitution added paragraph 4, that's subsection 4, to section 251. It wasn't there. Constitutionally, historically, it wasn't there.
Okay.
So it meant that Federal High Court never had any jurisdiction with respect to determining whether even the office or the seat of a member of a House of Representatives or a member of the Senate was to be vacant. It never had. So when in 2010 we had an alteration of the Constitution, we added subsection 4. And it was also specific only with respect to a House of Representatives and a Senate. Then, because the Constitution had the State High Court established separately as a different court from the Federal High Court, and then dealt with the jurisdiction of the State High Court under Section 272, specifically as jurisdiction for the State High Court. Meaning that if we never introduced subsection 3 or Section 272, it would have been only exclusive to the State High Court. The matters about the tenure or the office or the vacancy in the position of a governor or a deputy governor or a member of the House of Assembly would have been exclusive to the State High Court. But when we introduced subsection 3 or Section 272, it shared that jurisdiction. That's my argument.
Okay.
And unfortunately, for those who hold on to the argument that it's also exclusive, subsection 3 of Section 270 did not make any reference to exclusive jurisdiction. Unlike Section 251(1) that says the Federal High Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters in relation to those items from paragraph A down to S. Okay. If it was intended that the Federal High Court was to have exclusive jurisdiction, just like it was in 251 sub 1, it would have been so expressly provided under 272 subsection 3, the new addition to 272,
okay,
to say that even if it was provided under the jurisdiction of the State High Court, of course, ideally and arguably in jurisprudence, it shouldn't have been there under the State High Court at all. You wouldn't have had subsection 4, 251, so including these items under subsection 3 of 271.
All right.
There was nothing that would have prevented the National Assembly to say under subsection 4 that the Federal High Court shall have and exercise jurisdiction to determine any question as to whether the term of office or a seat of a member of the Senate or of the House of Representatives. There was nothing that prevented the National Assembly to add, even in this subsection 4 of 251, that was the primary provision for jurisdiction for Federal High Court. Nothing stopped them to add, including members of the House of Assembly, a governor and a deputy governor.
All right.
So if anybody is arguing, then of course the Constitution has created this lacuna.
All right, Henry.
That's my position.
Henry, let's listen to God's Power now. God's Power, can you hear me?
I can hear you.
You've listened to the arguments of your learned colleague, because you had earlier stated that it is expressed, there is no addition or subtraction, and that subsection 3 of section 272 should be taken the way it is seen. So what do you make of this?
I didn't get you. Sorry.
Can you hear me now?
Yeah, I can hear you.
I'm asking, what do you make of the arguments by your learned colleague?
By virtue of the first alteration, jurisdiction with respect to whether the seat of a member of the House of Assembly has become vacant rests with the Federal High Court. And that's the provisions of the Constitution. And I have said, if you interpret the Constitution and you feel that there is a lacuna, you have an option of the Constitution being amended. But no citizen, by virtue of interpreting the Constitution, should have extraneous factors that are not in the Constitution. If the Constitution wanted the State High Court and the Federal High Court to share that jurisdiction, the Constitution would have provided for it explicitly. The Constitution went ahead in section 272 sub 3 to say that jurisdiction, that is an extension of the jurisdiction of the Federal High Court. That jurisdiction with respect to that matter now rests to the Federal High Court. There is no other argument you can make with respect to this.
Okay.
Section 251 is explicit. Section 251 did not provide that a question with respect to the seat of a member of the House of Assembly, whether it has been declared vacant or not, that it rests with the State High Court. Nothing in Section 251 says so. Then you go to Section 272, sub 3. It specifically says that the question whether a seat of a member of the House of Assembly has become vacant rests to the Federal High Court. The express mention of one thing means the exclusion of the other. That's the law.
Okay.
If the Constitution has provided expressly that this jurisdiction lies with the Federal High Court. It excludes every other court, including the National Industrial Court, including the Customary Court of Appeal, including the Magistrate Court, including whatever court, by whatever nomenclature you want to call it.
Let's look at real matters now as it relates to Rivers State. So are you saying Justice Charles Wali's court did not have the jurisdiction to look into the matter and give the order it gave?
Mr. Canada, I've made that positions earlier before now. That courts, and I made the judiciary, the executive, the legislature are creations of the Constitution. They are limitless powers. Their powers are provided for in the Constitution. Courts have jurisdiction. If you do not have jurisdiction to determine a matter, you shouldn't even determine that matter, because every order you make with respect to that matter is void. You can't place something on nothing and expect it to stand. You can't. Jurisdiction, whether the seat of a member of the House of Assembly has become vacant or seized, rests with the Federal High Court. No state high court has that jurisdiction.
Okay.
No state high court. All the matters with respect to whether the seat of a member of the House of Assembly has been declared vacant or with respect to decisions of the Federal High Court.
Okay. So
any other argument we want to make vesting that jurisdiction in the state high court is an expression of sentiment and emotions, misconceptions of the Constitution, because it is not provided for. Remember, this is a Fons et Origo, section 1 sub 3. Let me read it for you. See what it says. If any other law, including your interpretation of this Constitution, if it is inconsistent with the provisions of this Constitution will prevail. And that other law, including your interpretation, will be declared null and void. This is the provision of the Constitution. Everything you want to say, every law made by any arm of government must be in compliance with the Constitution. Even you who want to interpret the Constitution cannot interpret the Constitution by adding extraneous factors. Those factors you want to add will be there, and the Constitution will always be upheld.
All right. Now, I've got one more question before I go back to Barrister Ekine. Now, you've said that the Justice Charles Wali's court did not have the jurisdiction to look at the matter it's looking at. Who then will make it right? Is it an appeal? Is it the Supreme Court? Is it the NJC? Who then would make it right? Because currently Justice Charles Wali has got an interlocutory injunction and is also going to look at the substantive suits.
Quickly. Well, we would say the Court of Appeal. But you see, what is also calls to question is what I call public opinion, on the judiciary. When citizens begin to question the legitimacy of courts giving judgment that are above their jurisdiction. You see, all of us, irrespective of your status, one day or the other, you approach the courts. Justice itself is rooted to confidence, public confidence, and confidence is lost when members of the public walk away from the court thinking that court judgment and orders are influenced by external factors other than legal principles. It is a question we need to answer, and it is beyond who should correct it. You see, one way or the other, the NJC, the Court of Appeal, even the judges themselves, we need to salvage the judiciary. Because a situation where we begin to have this kind of ex parte orders coming from courts that don't even have a jurisdiction to give such orders. I have said it before, it is a tragedy. It is a tragedy of monumental proportion.
Excellency Inda says, I was reading patiently, but I no come understand them. I guess you're talking about the various sections of the law of the Constitution that we've been reading. But back to you, Barrister Ekine. Barrister Ekine, can you hear me?
Yes, please. I understand that you are coming back to me, but I will wish that I hear better.
Okay. Oh my, it's noisy. God's power, can you please mute your mic, please? Thank you.
Hello?
Please mute your mic. It's noisy from your end.
No. I'm in a safe environment now. Can you hear me clearly?
I can hear you clearly. Okay, thank you. So back to you, Barrister Ekine. Can you hear me now?
Yes, Kalada.
Okay. Now, I was going to ask you this question. Based on how you've interpreted Section 272...
Based on?
How you have interpreted Section 272, subsection 3.
Okay.
I was wondering, who do you think should step in at this point? Do you think the NJC should do something about it, as we have seen them do in Kano State? Should he call the High Court justices or judges, to make them understand what the law actually says?
Kalaba, I'm afraid that if I'm on track, but let me say, it's not got to the point of invoking the powers of the National Judicial Council. One of the tenets of democracy really is judicial independence, and that also extends to judges to be able to freely entertain matters, determine matters the way they perceive the questions that are presented before them, provided they are not perverting justice and they are not misapplying the law. But even when they do so, the next hierarchy of the court is there for all of these contestations to be tested, Kalada. And that is why when a judge entertains a matter and then determines the matter the way the judge perceives it within the purview of the law, if you are dissatisfied, including when a court assumes jurisdiction, and then a party feels that the court ought not to assume jurisdiction, the party will approach the Court of Appeal to challenge that ruling assuming jurisdiction. So I do not think that it's a question of discipline in this regard yet, because the judges were convinced that looking at the subject before them, and let us not misunderstand one thing here, or rather generalize that all processes before the court are the same, even when they seem to appear to be similar. Kalada, are you still with me?
I can hear you loud and clear.
Okay, so the point I'm making, that each of these judges, with respect to them, have matters before them, and the processes before them are clear with respect to the questions that are put before them by the parties. You and I may not be privy to how those questions are couched. Sometimes the way you couch your prayers in a matter may significantly depart from the way another matter appears to be before a court. So for me, when the judges assume jurisdiction or decline jurisdiction, the party that is dissatisfied will go to the Court of Appeal and espouse the law to argue that the court ought to have jurisdiction or ought not to have jurisdiction. And the Court of Appeal will address that. If you're still dissatisfied, the Supreme Court is still there. The National Judicial Council is in respect to discipline when judicial officers are found erring in terms of, yes. But holding your view is not erring, as a matter of fact. Holding your view, my colleague and I are arguing the same constitution here. I will imagine what those who are listening to us will be saying, that two lawyers are holding divergent views with respect to the same constitution. But that is because we are seeing it from different angles. But we ought not to see it from different angles. So if I disagree with him, you can imagine that when he was speaking, I just keep quiet. When I am speaking, he keeps quiet. Because we clearly are on different perspectives with respect to what the constitution is saying. But let me make one point, Kalaba, that he has mentioned consistently, applying one of the tools of interpretation of statute, that the mention of an item is a clear exclusion of anything that is not mentioned. Just to say, listen. And what applies to section 1, it will mean that he should agree with me that the first mention of the items that constitute the subject for the division of the High Court to mean that it is an entity or individual authority. What the constitution not said is exclusive to the federal act. Okay. That's what we intend. Then we should go to the next oration, which is about the features, and consider to alter the provision of section 272, subsection 3. And I would recommend it should be taken away from section 272 that deals with the jurisdiction of the state high court, so that we know that the state high court has nothing at all whatsoever to reference to it. And take that to add to subsection 4 or section 251. You don't confuse the situation where section 251 is clearly dealing with jurisdiction of the federal high court. Section 272 is clearly dealing with jurisdiction of the state high court. Then you now come and model inside section 272, subsection 3, and say that the federal high court shall have jurisdiction to deal with some matters there. So that's why I said, to me, it's a concurrent jurisdiction, and at best, like he said, it's an additional jurisdiction to the federal high court, where its own jurisdictions are established under section 251, subsection 1, subsection 2, subsection 3, and subsection 4.
All right. My next question will be, since there is going to be an appeal, there's room for an appeal, the matter doesn't end here. So can we then say that, for instance, now that there is the interlocutory injunction, it can be appealed, of course, restraining...
Sorry, please?
I was saying, since both of you have said that there is room for appeal, there's ended at the high court level, it means that...
I'm afraid I am sure that the appellate court have actually determined the particular argument I'm having with my friend with respect to the jurisdiction, the federal high court to be exclusive, with particular reference to declaring the seat of a member of a state house of assembly. Because since 2010, the first alteration, all the processes I have seen, including the ones that some of the lawyers have filed recently that I've had opportunity to see, they never made any reference to any authority of the superior court directly holding that the federal high court has exclusive jurisdiction. But we are struggling with the tools of interpretation of statutes, just like my colleague and I are doing now. Even my colleague had struggled with the tools of interpretation to say, relying on the tools of interpretation, that section 272 sub 3, which is quite unambiguous and clear, but we are imputing exclusivity to it. There is no exclusivity at all under subsection 3 of 272. But that's why I would suggest, and I would want all of these matters to get to the Supreme Court, particularly with this respect, because some of us are still holding on to the argument that the matters that are subsisting in the state high courts are valid.
All right.
Despite, with respect, the holding of the Honorable Justice Gbasam Okogbule, an erudite judge, I must say. I know I've had matters before him, very intelligent judge. Despite that, let us see what will happen at the Court of Appeal. In law, there are some matters we would love for, not for the fact that we always will be cantankerous to want matters to continue at the appellate court, but so that we have a finality of a position so that my colleague and I wouldn't have been arguing this, would have not referred to what the Supreme Court would have said.
All right.
So let's have all this get to the Supreme Court.
Okay. I'm out of time. Yeah, God's power. Let's get you.
Let me just add one point. Just one point. The argument that because there is no exclusivity, there is no use of the word exclusive in section 272 sub 3, and therefore, just hold on, and therefore, the High Court can exercise that jurisdiction. Let me ask my do you know that even in section 51 have to do with jurisdiction of the High Court, there's no exclusivity. So you can negotiate the provisions of constitution. But the main point that word exclusive, not go ahead to mention the specific 251. It's not where the constitution says it's exclusive. So the main point that the constitution didn't say is exclusive.
Are you referring to 251 subsection 1? It's exclusive. Except you are referring to subsection 4.
Okay, gentlemen, I'm sorry, I would have to step on the brakes now. My time is up. I've got to go. But thank you very much, Ekine and God's Power Egbule. I guess this conversation would have to continue some other day. Section 272, subsection 3. All right, then.
It's my pleasure.
All right, thank you, gentlemen. I should open a court, I guess, so we can have lawyers come argue. But a commercial break now.
We announced that Providus Bank has now started operations in its customer-friendly lifestyle branch in Port Harcourt. Providus Bank is located